Hey everybody, welcome back. Court cases are a huge part of the AP exam, so smash that like button to find out exactly what you need to know about all 14 of them. For every case, you need to know 4 things: facts, issues, holding, and reasoning. The facts refers to the background info before it became a Supreme Court case. The issue is the legal or constitutional question of the case. The holding is the court's ruling, and the reasoning is the court's explanation of the holding. And the decision combines all 4 of these when discussing the outcome of the case. First up, McCulloch versus Maryland. Congress established a national bank even though nothing in the Constitution said they could do so, and some state governments didn't like that very much, so several of them, including Maryland, placed a tax on the bank. There are 2 issues in this case. Can Congress create a national bank, and can states tax the national government? A unanimous Supreme Court held that yes, Congress can establish a bank, and no, states cannot tax the federal government. It's an overwhelming victory for a stronger federal government. The court reasoned that through the necessary and proper clause, Congress has implied powers, and is not limited to only its enumerated powers, so it can do things that are not specifically listed in the Constitution. And it used the supremacy clause to assert that the federal government is superior to state governments when the 2 conflict, so states could not tax the federal. Next, U.S. versus Lopez. A high school student in Texas allegedly brought an unloaded gun to school and was arrested for violating the federal Gun-Free School Zones Act of 1990. The issue before the court was, does Congress even have the power to make this law, or did they exceed their power to legislate using the Commerce Clause? In a 5-4 ruling, the Supreme Court held that the federal Gun-Free School Zones Act is unconstitutional, striking down the law and overturning Lopez's conviction. The court reasoned that possession of a gun in a school zone does not substantially affect interstate commerce, and the Commerce Clause does not grant Congress endless power, and that some powers are reserved to the states by the 10th Amendment. Huge dub for states' rights. Next, Baker versus Carr. In violation of its state constitution, Tennessee didn't reapportion its congressional seats for over 60 years, leading to districts of very unequal populations. Honestly, this case is complex, so I'm really simplifying things in this review. Remember, I have videos on every single case, so check those out if you need more details on some of them. The most direct issue before the court was, does the federal judiciary have jurisdiction to rule on cases about apportionment and redistricting? The court held that apportionment and redistricting challenges are justiciable in federal court because they raise non-political questions. The majority reason that courts can rule on unequal apportionment and redistricting plans that may violate the 14th Amendment's Equal Protection Clause, meaning this is a constitutional issue and affirming the appellants had the right to sue. The court's ruling in this case led to the one person, one vote principle of voting equality in House elections, meaning that everybody's vote should have roughly equal power in all districts. This means that drawing districts of very unequal populations is unconstitutional. Shaw versus Reno is also about how congressional maps can and can't be drawn. North Carolina's state legislature created a bizarrely shaped district specifically to increase black voter representation in Congress. They did this to comply with the section of the Voting Rights Act of 1965, which banned racial discrimination in voting policies. The issue before the court was, can state residents challenge in federal courts racially gerrymandered congressional districts? In a contentious 5-4 ruling, the court held that districts created under the Voting Rights Act may be constitutionally challenged by voters if race is the only factor used in creating the district. Practically speaking, this meant that congressional districts can no longer be drawn based only on race. The court reasoned that drawing a congressional district based only on race violated the Equal Protection Clause and opposes the colorblind ideal of the Constitution, which would basically prohibit racial distinctions. Next up, Marbury versus Madison. This case is hugely important, but the facts and issues can be a little bit confusing, so don't stress it too much. John Adams made a bunch of appointments at the end of his term. A few of them didn't officially receive their appointment before he left office, and James Madison refused to deliver them, so Marbury sued to get his job. The issue before the court was, does Marbury have a right to his commission? But more importantly, it morphed into, does the Supreme Court have the authority to order the delivery of the commission? The court held that Marbury was entitled to his commission, but the court couldn't grant it because part of the Judiciary Act of 1789 was unconstitutional. With this decision, the Supreme Court gave itself the power of judicial review, tremendously expanding its power. The court reasoned that based on the Supremacy Clause, the Constitution is superior to federal laws. So if Congress passes a law that is contrary to the Constitution, it's the Supreme Court's job to uphold the Constitution by striking down the unconstitutional law. The next 7 cases deal directly with civil liberties, beginning with Ingle versus Vitale. The state of New York passed a law that public schools would begin the day by encouraging students to recite a prayer. The issue for the court was, does reciting a non-denominational prayer in public schools violate the First Amendment's Establishment Clause? The court held that states cannot hold prayers in public schools, even if prayers are voluntary or not specific to a certain religion. so they struck down the New York law. The court reasoned that state-sponsored prayer and religious activities in public schools violates the First Amendment's Establishment Clause that says, Congress shall make no law respecting an establishment of religion. The court decided that this also prevents governments from promoting religion. Our next case also deals with religion, Wisconsin versus Yoder. Wisconsin had a law that required all children to attend public schools until the age of 16. 3 Amish students stopped attending public school at the end of the 8th grade, and the parents were fined by the state for violating the law. The Amish families argued that high school promoted values contrary to their religious beliefs. The issue before the court was, did Wisconsin's mandatory school attendance policy violate the Constitution by punishing families who didn't want to send their children to school for religious reasons? The court ruled in favor of the Amish families, holding that Wisconsin may not force Amish students to attend public school beyond 8th grade. But why? The court's reasoning is focused on the Free Exercise Clause. While the state has a legitimate interest in promoting compulsory school attendance, when it comes into conflict with a person's religious beliefs and practices, the person's right to freely exercise those religious beliefs is more important than the state policy of mandatory school attendance. Next up, a pair of free speech cases with opposite outcomes. First, a World War I era case, Schenck versus US. Opposed to the war, Charles Schenck distributed leaflets urging men not to participate in the military draft. For doing so, Schenck was arrested and convicted for violating the Espionage Act of 1917, which made it illegal to obstruct military recruitment. The issue before the court was the seemingly simple question, did Schenck's conviction under the Espionage Act violate his constitutional rights? Perhaps surprisingly, the court unanimously upheld his conviction, holding that the Espionage Act was in fact an appropriate exercise of Congress's wartime authority. The court is basically making an exception because of the war, allowing Congress to restrict speech that it wouldn't normally be allowed to restrict. The lasting impact of this case is that there may be time, place, and manner restrictions to speech. The court reasoned that speech creating a clear and present danger was not protected by the First Amendment's free speech protections and therefore could be restricted. The court no longer uses the clear and present danger test, but it does still allow for time, place, and manner restrictions on speech. Our next case is 50 years later during the Vietnam War, Tinker versus Des Moines. A group of students decided to wear black armbands to protest the war and call for a truce. School administration didn't like that, and so 3 of them were suspended for refusing to remove their armbands. The issue for the court was whether schools prohibiting black armbands as a form of political protest violates the students' free speech rights. The majority held that students do in fact have free speech at school, and prohibiting students from wearing armbands as a political protest violates their free speech rights. They reasoned that students' First Amendment right of political symbolic speech overrode school officials' concern for potential disorder. To justify suppressing speech, the school must prove that it would substantially interfere with the discipline and operation of the school. But make no mistake, the key takeaway is that the court definitively established that students have free speech rights at school. Next, New York Times versus US, another Vietnam-era case, has a similar vibe. In 1971, a man leaked 7,000 pages of a classified document known as the Pentagon Papers, a massive report on US involvement in Vietnam, to the New York Times and Washington Post, and the newspapers began publishing reports on the document. The Nixon administration sued to block the publication of the papers. The issue for the Supreme Court was, did the Nixon administration's attempt to block publication of classified information violate freedom of the press? The Supreme Court ruled that government did not have the right to block publication of the Pentagon Papers. To justify blocking the publication, the government would have needed to show that publishing the papers would have caused grave and irreparable damage. Not surprisingly, the court's reasoning is centered around the freedom of the press. As a result of that freedom, there is a heavy presumption against the constitutional validity of governmental claims of prior restraint. And this is true even in cases involving national security. In simple terms, this means that it's extremely difficult for the government to justify censorship, even in national security issues. From national security, let's talk about guns and McDonald versus Chicago. The city of Chicago created an effective handgun ban by requiring residents to have a license for handguns and then denying all license applications. The issue was, does the Second Amendment's right to bear arms apply to the states through the 14th Amendment, therefore preventing this kind of gun ban from being implemented by states and local governments? In a bitterly divided 5-4 ruling, the court held that the Second Amendment's right to bear arms for the purpose of self-defense applies to the states, striking down the Chicago handgun ban. The reasoning is that the Second Amendment establishes an individual right to bear arms, and through the 14th Amendment's Due Process Clause, it was made binding on the states, thus weakening state and local governments that could no longer violate a person's Second Amendment rights. Next up, everybody's favorite Florida man, Gideon versus Wainwright. Gideon allegedly broke into a pool hall and stole some money. There wasn't a whole lot of evidence, but he was arrested. When he appeared in court, Gideon, who was homeless, asked the state to provide him with an attorney since he couldn't afford one. However, the judge denied his request, insisting that in Florida, the state only had to provide an attorney in capital cases. Not surprisingly, Gideon was found guilty. The issue before the court was whether the Sixth Amendment's right to counsel or an attorney applies to felony defendants in state courts. A unanimous Supreme Court held that states must provide attorneys for defendants who can't afford one, incorporating the right to an attorney. The court's reasoning in Gideon means that the Sixth Amendment's right to legal counsel applies to defendants in state trials through the 14th Amendment's Due Process Clause. Next up, the all-time GOAT civil rights case, Brown versus Board of Education. Black students in several states were denied admittance to certain public schools based on race. In this landmark case, a unanimous court held that racial segregation of public schools allowed by the separate but equal principle of Plessy v. Ferguson was unconstitutional. The court reasoned that racially segregated schools violate the 14th Amendment's Equal Protection Clause. The court ordered the desegregation of public schools. However, one of the unfortunate legacies of this case is that it shows the weakness of the court as a policymaker. Many states refuse to desegregate their public schools, and some places even close their schools altogether rather than follow the court's order. Okay, and finally, Citizens United versus FEC. This one gets complicated, but at its root is the 2002 Bipartisan Campaign Reform Act, better known as BICRA. BICRA made several changes to campaign finance laws, including banning corporations and unions from independent political spending in the weeks before an election. The FEC said that a conservative group called Citizens United violated the law, so Citizens United sued. There were several issues before the court. We'll focus on two. Can political speech of corporations, labor unions, and associations be banned? And can direct contributions by corporations, labor unions, and associations be banned? In an extremely contentious 5-4 ruling, the court held that corporate and union funding of independent political expenditures cannot be limited. On the other hand, the court upheld BICRA's ban on corporate direct contributions to candidates. So let's be clear, corporations, unions, and associations can raise and spend unlimited money on independent political speech, but they may not give any money directly to candidates. The court's reasoning was that based on the First Amendment's free speech clause, corporations have the right to engage in political speech just like individual people. And there you have it, everything you need to know about the required cases. Smash that like button if you're watching this right before the AP exam, and until next time, this has been a La Money production. Thanks again for watching. I truly appreciate you so much. If you're stressing about the exam or your class, you might be interested in checking out the Ultimate Review Packet. 3 practice exams, tons of multiple choice, FRQs, plus incredible study guides. You got this, and I will see you in the next video.